Good afternoon. My name's Steve Block. I'm the moderator today on this panel. And before I introduce our distinguished panel, which I'm really excited about, I must say I've been particularly impressed with the scholarship of the previous panels throughout the morning and into this afternoon. Impressed with the scholarship and also, I think, inspired. I think we probably all share that to some extent. And I just have to tell one little brief, I just need to acknowledge that the first time I met Paul Paton, who I'm very appreciative of inviting me to participate today, we hadn't met before, and we were both at a McGeorge alumni-sponsored MCLE program for the Long Beach chapter for McGeorge graduates, and I hadn't met Paul, and I was doing a PowerPoint presentation that I had prepared myself, and I was right at the section talking about the use of discovery referees, which is something that I'm engaged in from time to time in my practice, and I was getting to this part of my presentation, and what I'm trying to do is to distinguish the scholarship you've heard and the unfortunate circumstances under which I met Paul Paton, a very impressive and scholarly man. I looked over in the corner at the Long Beach Ramada or Hilton, wherever it was, and there was this handsome guy with the dark, the quintessential goatee and ready, he had all these gold embossed folders with him and audio visual, and I just gotten to the point where I rhetorically asked the crowd, if you have somebody on the other side of your case, your litigated case, that looks like this, you need a referee. And the first one I had first photo that came up was Braveheart. And being down in Los Angeles, and Judge Feibel's really going to appreciate this. Are you still here, Your Honor? You're going to have to wait till the end of the story to really get the appreciation. And so I said, or like this. And I put up a big gargantuan picture of the then ginormous Ray Ma'aluga, linebacker for USC, out on the field in his cardinal and gold, and I turned on the music of Conquest for those of you on the West that know West Coast football, and I expected this crowd just to explode, like nah, nah, USC thing, and there was like one, like a Wally Coxey guy, like way in the back, and he's just like, yeah, I'm like, yeah, go Trojans, and so. But being a good trial lawyer, I was resourceful and prepared and quickly segued to the next slide, which was a UCLA split in, catching a touchdown pass in the end zone on a beautiful LA day. And I put on Sons of California, and this place erupted. But it was that kind of scholarship that Paul saw me involved in, so I feel that I'm lucky to be here today. Thank you. I'm going to introduce the individuals on the panel in a moment, just to kind of put this in perspective, maybe give us a little bit of a roadmap. This is the little bit amorphous, sort of Montessori panel, roundtable. We expect, hope that there will be some participation. And what we're going to be talking about today, in large part, is the perception of the judiciary and the standards of civility that lawyers are supposed to comport their conduct to. To what extent do they apply to judges? What do judges do with lousy lawyers in the courtroom? What do lawyers do with lousy judges in the courtroom? And then we're going to move from there into a discussion or roundtable of judges involved in politics. Where can judges become political and speak out and exercise his or her right of free speech versus conduct that's considered inappropriate for a judge to engage in? And also looking at political issues that are outside, perhaps, the third branch, the third co-equal branch of government. In other words, can they speak in intra-branch issues? If not, can they speak on extra, outside the judicial branch issues? We're going to talk about a number of scenarios that come up for judges. And finally, we're going to talk about how the media portrays all of us, lawyers and judges, and what impact that can have on the legitimacy of our system of justice. I mean, what do we share in terms of challenges, both as lawyers but primarily judges, in terms of what the public thinks about us, depending on what happens in the media? And to what extent can judges and lawyers get involved in the media and be part of that? So that's just an overview. The first thing I'd like to do is to introduce each of these gentlemen. I'm going to have them make a presentation so that you get the benefit of them talking. And then after that's finished, we'll start our discussion. And we do encourage audience participation. I did find one good quote from Thurgood Marshall in 1981, which I thought was apropos. Quote, "We must never forget that the only real source of power that we as judges can tap is the respect of the people." And I think that's a good sort of truism, axiom, bottom line that we all know, but we have to be aware of in our practice. So, without further ado, gentleman to my far right, your far left, Robert Hawley. Bob is the Deputy Executive Director of the State Bar of California. He's a graduate of Hastings, where he got his JD degree, and then he completed an LLM degree at NYU. He was in private practice, involved in employment litigation for about 15 years, and as mentioned, he's now with the State Bar, and we're really happy to have you here, Bob. Next to Bob is Ellie Wold, who is currently an associate professor of law at Sturm College of Law, University of Denver. Professor Wald has a, I don't know what a SJD degree is, but like a JD degree?
It's a silly JD.
Silly JD degree, and a master's in law from Harvard. And he did his undergraduate BA and LLB, master's in business. I'm not big on the Latin thing. Okay. In Tel Aviv University. Before becoming a professor of law, he was involved in litigation as an associate litigator with Paul, Weiss, Rifkin et al. In New York. His particular interests are the American legal profession and jurisprudence, legal ethics, and corporate law, with some particular sub-interest in attorneys' loyalty to clients, lawyer mobility, attorney-client communications, and currently serves on the standing committee of the Colorado Rules of Professional Conduct and their ethics committee. And thank you for being here, Professor. The local favorite, the last gentleman to my right, is our very own Judge Loren McMaster, who is a distinguished Superior Court judge here in Sacramento. I say local favorite because at least, I mean, I haven't done a scientific sampling, but Judge McMaster is one of those really fine jurists that works really, really hard, gets up every day, goes down and shovels coal down in Department 53 in Law in Motion, and delivers the kind of product that we as lawyers expect, both the good, the bad, and the ugly. I mean, depending on what you're trying to get. But he's greatly respected. He was Judge of the Year several years ago, awarded by the Sacramento County Bar Association. He's been active in many, many local activities, bar-related and bench bar-related programs. He's a graduate of UC Davis and has been on the bench for 10.5 years. Correct, sir?
Correct.
And he looks really, really good in a kilt. But anyway, I'll let that go. So with that, let me ask Bob Hawley to come on up, and thank you. And I don't know if I said thank you, but Dean Parker and Paul, thank you so much for the ability to participate in this wonderful group.
We're each going to take about 10 minutes, as was said, to sort of introduce ourselves through some observations and such, and then hopefully engage in an interactive discussion. I view my role here as being having heard so much of the scholarly discussion that has taken place so far, as being the resident simpleton. I am a regulator. Working for the State Bar of California. My career has been devoted to a great extent regulating attorneys, And I'm a defense management side labor relations and employment lawyer, and spent my career, the other part of my career, doing that. So there's two things that I know, and that's labor and employment law and attorney regulation. And I see everything through that prism. And so the observations that I'm going to make as I rocket through them, and we have about 10 minutes, so I think I'm going to make about 10 observations very quickly, and then sit down and we'll move on, will be on point with respect to some of the discussion that is relevant to this panel, but it will incorporate some of the discussion that we've already had so far in this day of a very significant scholarship and discussion, all through my, as I said, very limited, simple prism. One observation is this discussion of ethics. Judicial ethics, legal ethics. I have given up using that term in attorney regulation because ethics is a philosophical subject that you can argue about till life is over and you will never agree. The value of life, morality, and such things. You cannot enforce ethics. You enforce codes, and we have professional codes, and those codes are codes of ethics, if you want to call them there. I'm not going to go there. They are regulatory standards, and that's how you conform people to that behavior. You have the rules of professional conduct, you have codes of judicial conduct, and you have regulatory agencies that enforce those things. And it may simply be language, but it does mean more, in terms of how you get people to conform to that. Because as I have said, there's a thing called the vehicle code in California, and it tells you how fast you can go on I-5. And I zip down I-5, and I never do the speed limit. I go as fast as I can possibly go as long as other people pass me. I periodically get pulled over by the CHP, and I could have a philosophical discussion about what an ethical driver I am, but I'm going to get the ticket. And that's what it's about. And that is what keeps me from going over 80, because it's a fear, that I'm not going to get past and I'm going to get more, than a ticket. So that's one observation. The second one is that I see everything through the employment relationship, and everything that I have heard today is about the employment relationship. The administration of justice is an industry. We are all employees in that industry, working in various workplaces, around. We have various positions. We have job descriptions, whether they're actually called that or not. But we have duties to perform and assignments that are given, and we are accountable, to a regulatory agency as a boss or whatever else it is. And in my view, what the workplace is about, wherever it is conforming tribal behaviors that are inherent in human nature to an organizational environment, that is our multi-complex industrial workplace setting. And every relationship that you have, whatever it is based upon that dynamic. Eliminating bias, employment discrimination, whatever it may be. There are these standards that managers and HR professionals have been trying to enforce from the beginning of time, and it's eradicating all these implicit biases and everything else that we've been talking about today. It doesn't work because we are tribal animals, and we're never going to rid ourselves of those things, but we got to keep trying. We have skill sets. It's a hiring promotional standard, and the Peter Principle is alive and well, meaning that you are always going to reach repose in whatever your career path is, one level above your highest level of competency. So by definition, the best possible lawyers are going to become the worst possible judges. And just think about it. What makes a good trial lawyer? Being isolated and quiet and demure. No, it's high drama. And if that person aspires to being promoted to a judge, they've got the wrong skill set. And so we need to look at skill sets and match skill sets to the demand of what the actual job description is. Judges are not partisans, and they're not politicians. Our system of government was designed in a beautiful way, to have the executive branch totally responsive to the massive political base, to have the Senate responsive to the next smaller subunit of that, and then to have the House or the legislature responsive to the next smaller, demand of the populace, and then to have this place that we were not accountable to the populace at all. Now, that's lost on the human and on the public, but that is essential to the checks and balances, and the judicial branch cannot and should not ever play politics. The most democratic group of people known to humankind, pure democracy, is a lynch mob. They were all together, they voted, it was unanimous, and at the end of the day, somebody's swinging from a tree. Democracy is not inherently good. And so we need folks, not the judges are God, but they do need to be accountable and are to their code of ethics and through a regulatory structure. In terms of the materials or the subject for this particular panel, in the description in the program, there are posed several questions. And so I thought I would just, as I said, I am a simpleton, so every question's got an answer, and it's, kind of straight up. And then, we'll kind of go from there. So I was going to answer these questions. What responsibility do judges, lawyers, and the public have for the public perception of judiciary? We have the responsibility to be a role model, to walk the walk and talk the talk. That's all we can do, We need to be out there showing people what it's about as opposed to engaging in marketing. Marketing doesn't really work. We're not selling the administration of justice. We are applying, I guess, the administration of justice and furthering the administration of justice. Does civility in the courtroom matter? You betcha. And how can it be balanced against zealous advocacy? Well, it's zealous advocacy, not zoo advocacy. It's good manners. You can be zealous very civilly, and the best lawyers are. Do civility principles and requirements stifle legitimate adversarial behavior? No way. It's adversarial behavior, not barnyard behavior, like I said before. Do judges have a role in enforcing those kinds of standards? Yes. Are meta portrayals of judges and courts part of the problem? Yeah. Could they be part of the solution? Yeah. Should judges speak out? Depending on what? Not about political issues. What impact did media coverage of the Sotomayor confirmation have on public perceptions of the judiciary and the public branch? Nothing. None.
That ends this
As a final note on that point, with respect to media perception, I was going to invite you, as was earlier commented, to your hymnals before you, and to the materials, and it's kind of hard to find them because it's not page numbered, but in the materials that I compiled, there's nothing original, not one original word in there. I simply cobble out of the judicial codes and cases and things various observations about this whole area of civility and media and such. But in there is a reminder that controversy within the judicial branch is not new. And this is the Impeach Earl Warren media campaign that took place in the 60s. Some of us will remember. Here's a wanted poster for the guy. I mean, he's iconic in terms of our profession, and yet there was a very serious media campaign to impeach him. And then there's another cartoon here from decades earlier about FDR's effort to stack the bench, the switch in time that saved 9, where he was going to expand the Supreme Court because he didn't like the way they were ruling on his social justice program, so he was just going to add a few more judges that he, of course, would have controlled. And so the issues we're talking about are perennial. I guess that's my final point. But that doesn't mean that we should give up on them. It means that we should just try harder.
I'm not exactly sure how to follow that. So I'll start with an apology. In addition to having an accent, as Steve told you, I was born and raised in Israel, so I do have, I'm aware of a thick accent. Several judges, in fact, have told me as a compliment, oh, don't worry about it at the end of litigation, which of course made me worry about it even more. But in addition to that, I have a 1-year-old baby, And my wife and I are living proof that when you have a baby, many of you will know, at any given point in time, somebody is sick, right? So I have this cold that, so in addition to the accent, this nasal congestion that you're hearing is going to make this, the next 10 minutes probably a little bit challenging, so my apologies. So before I get started, I want to thank, of course, the Dean, the McGeorge Law School, and of course, Paul. I have a very short Paul story. The Paul Paton story I have is a few weeks ago. I'm trying to schedule a phone call with Paul so we can coordinate. And he sends me an email and he says, I'm at the Olympic Games. And I'm thinking, the Olympic Games take place once every 4 years in the summertime, and we still don't care about them. Right? So what is he talking about? So I sent him like a question mark, and he says, oh, I'm in British Columbia, and there's an Olympics going on. And what I still didn't understand, he simply said, I'm Canadian. All right, but thank you so much. I didn't understand. Thank you so much for inviting me. I'm delighted to be here today, and I've learned so much throughout the day and look forward for more learning tomorrow. And in part, the reason why I've learned so much is because I have to admit that I'm completely new to judicial ethics. So in the past 10 years, I've been a legal ethics professor at the University of Denver, but I mainly think and write about lawyers' ethics. And in fact, I have to concede, I conducted a poll story. I spoke to some of the people who teach legal ethics who are in the audience. Many of us don't teach judicial ethics at all, right? So notwithstanding the fact that judicial ethics is covered by the MPRE, the part of the bar exam that covers ethics, we still, some of us, like myself, know relatively little about the subject, and we don't teach it because we don't know a whole lot about it, right? So I'm a newcomer, and I want to tell you briefly how I came about to think about issues of judicial ethics and why I was delighted to be invited and to participate. And in order to do so, let me tell you quite briefly, or set up the stage by talking about how I present to my students the issue of lawyers' regulation, how it is that we regulate lawyers. And I oftentimes tell my students that by and large, there are three bodies of norms that we, the legal profession, we use to regulate lawyers. The first one is obvious to all of us, law students, law professors, judges alike, which is there are legal rules, right? And one can break that category into, of course, malpractice lawsuits. That's one way to regulate the conduct of lawyers after the act, right, ex post. But then there's, of course, the entire apparatus that gives some of us a job, the disciplinary apparatus, right? So to sum up, one means by which we regulate the conduct of lawyers is, of course, we either file lawsuits against them after the act, or we ask the disciplinary authority to investigate allegations of wrongdoing, right? Legal rules. But that's not how we regulate, that's part of how we regulate lawyers' conduct. It's not all. Of course, the market regulates the conduct of lawyers. And about 5 years ago, the prime example would have been insurance companies. So any lawyer here in the room who recently tried to purchase an insurance policy, right, a malpractice coverage, will tell you that in certain areas of law, it's becoming harder and harder to purchase coverage. And insurance companies, these are private third parties, are becoming powerful actors regulating the conduct of lawyers. And in some instances, even driving some lawyers out of practice areas because they cannot afford coverage, right? But I don't have to give you that example because in the wake of our Great Recession, there is now, at least in the area that I specialize in, that is large law firm practice, market regulation includes very powerful clients. And those of us who practice for law firms like Morrison, some of the great law firms have been mentioned, Morrison and Forrester and others, know that clients now become extremely demanding. Gone are the days where clients accept hefty bills from lawyers, right? And clients now intervene, and the general counsel will intervene and will oftentimes micromanage not just the bill, but in fact the staffing, right? How many lawyers would work on a particular transaction? What will the rates be? What will the caps be? Who else would you represent? Whether or not you would outsource some of the work overseas. And in fact, there's an interesting question that Charlie, again, I discussed yesterday, which is, what should a lawyer do when the client says, listen, I want to know exactly how you charge your fees in the following sense. I want to know what is your profit margin, and I want a piece of it. So if you're telling me, for example, that you're going to send the product, if you're going to outsource some of the work, for example, to India, and you're going to buy the part of the work for $10 an hour, I want to know that, so when you charge me $250 an hour, I want to know exactly what's going on. Right, so again, to sum up, the first two elements of regulating lawyers is the legal rules, discipline and civil liability. There's the market, insurance companies, clients that grow in sophistication. And of course, there's what we're all familiar with, the third element of regulating lawyers' conduct, social norms. Right? So some of us are members of Inns of Court, and some of us have colleagues, and some of us realize that we are not one-shot litigators, and will appear before the same judge and might litigate against opposing counsel again and again. And we, to the extent that we can, we try to be civil, right? Because otherwise we might live to regret it, right? So this is, in a nutshell, how I open, by and large, every legal professional legal ethics class, and I talk about how the class will cover mostly the legal rules, and mostly in Colorado, both the Model Code of Professional Conduct and the Colorado rules, and in California, the California rules, right? Right. Have you noticed something peculiar about this presentation? I haven't said one word about judges, not one word, right? So that began to trouble me because when I went to law school and when I was a litigator, we were very much afraid of judicial regulation of lawyers. And we, as a litigation firm, we were very much aware that if you misbehave in court, there's yet another component of regulation, which is a judge that has at his or her disposal not only the rules of professional conduct of the jurisdiction if you're in state court, but also Federal Rule of Civil Procedure 11, and a few other federal rules of civil procedure, and evidentiary rule, and of course the inherent power of the court, so on and so forth. Judges are extremely powerful, as they ought to be, in their ability to regulate lawyers. So I began to wonder, why is it that, at least in this standard presentation that is not my own, of lawyers' regulation, we don't talk a whole lot about judicial regulation of lawyers. And as I began to prepare for this conference and do some readings, I discovered the following, which I want to just share with you, and then perhaps we'll use it later on as the kind of launching pad for a discussion that we can all have. And of course, like I said, because I'm new to this, I'd love to hear from any of the judges here. But here's what I think the tentative state of affair is when it comes to judicial regulation of lawyers. We ought to draw a distinction between state judges and federal judges. Why? Because, let's start with state judges. Like I said, state judges have enormous power. There's no disputing the fact that state judges have the power to regulate lawyers appearing before them. There's no disputing that at all, right? But there is a question about whether judges actually exercise that power, whether they in fact regulate lawyers appearing and practicing before them. And as I read the literature, and mostly a lot of empirical literature that has been published in the last 10 to 15 years, it appears that state judges are often reluctant to regulate lawyers appearing before them. Now, I'm not talking about the egregious cases, but by and large, it appears that, and this is what the literature reports, that state judges are somewhat reluctant to regulate lawyers who misbehave in their courtroom for several reasons. And some of them, interestingly enough, of course, we touched upon in earlier panels. Right? So some of the issues have to do with the fact that some judges are facing elections or re-elections campaigns or confirmations hearing, so on and so forth. Some judges have to raise money. And it's not, again, we're not talking about egregious cases. Obviously, judges will regulate lawyers who severely misbehave, but there's, of course, the issue that notwithstanding the fact that judges are ideally situated to regulate lawyers who misbehave in front of them, there's, of course, the practical issue that judges realize, and all of us ought to realize, that judges that have to stand for election, re-election, and campaign, and money, and fundraising apparatuses, perhaps have an institutional reason and a structural reason not to be at the forefront of regulating every kind of attorney misconduct in front of them, right? And to expect them to do so is perhaps not to understand the realities the judges are facing. So that's one set of considerations. The other set of considerations that actually came from an extensive study interviewing judges was to suggest that you, law professors who teach legal ethics, you don't quite understand what judges actually do. And a lot of judges said, don't misunderstand, it's not that we are not very much concerned as a secondary matter with the practice of law and the ethical practice of law of the legal profession, except we have a docket of cases. And we are very much concerned with the efficient and fair disposition of cases in front of us. And when lawyers misbehave in a way that affects the fairness and efficient disposition of a case before us, of course we'll regulate them. But when lawyers misbehave, say, by violating a rule of professional conduct, that has no impact on the litigation before a judge, and the judge is also facing a significant docket of cases and the obligation to conserve judicial resources, to ask the judge perhaps to regulate lawyers in the name of the ethical practice of law abstractly construed, that is perhaps asking a lot. Okay? Let me conclude briefly. So this is just kind of the tip of the iceberg, right? So there are some interesting reasons why perhaps the assumption, the easy assumption that of course judges ought to regulate lawyers who practice before them, of course, and it's an easy proposition. Why don't they? It's a complicated issue that we ought to talk about, and I hope we will in a minute. Let me just kind of say that at least what I've been able to discern from the literature on federal judges is that everything we said about state judges holds, of course, without the issue of election. But there's another complicating factor, which is that all of you, of course, know, at least if you're a state judge and if you wanted to invoke a code, you would invoke the code in the jurisdiction in which you adjudicate, right? And so in this case, we'll invoke the California Rules of Professional Conduct, right? Right. But if you're a federal judge, that is not an obvious, what code you will invoke is not an easy question at all. Because as I'm sure as you know, some federal districts, in fact, follow and apply the rules of professional conduct that have been adopted in the jurisdiction in which they preside. But as I'm sure you also know, some federal districts have declined to follow the rules of professional conduct in the jurisdiction. So did you know that 10 federal districts have in fact adopted the ABA model rule of professional conduct as the rules of ethics applicable in their district? So I actually I stand corrected. I always tell my students that the ABA model rules of professional conduct are good law nowhere except for the exam in legal ethics in law school and the MPRE exam, but that turns out to be wrong because in 10 federal districts, it is the rule. Those are the applicable rules. And of course, I do not need to tell the judges in the room that there's an entire apparatus of local rules, right? And there's a few other complicating factors that at least suggest that even if a federal judge is interested in disciplining a lawyer and is interested in disciplining a lawyer by invoking a code of legal ethics, it's not entirely clear what rules apply. And if you are a lawyer with a national practice and you appear before different kind of federal judges, say immigration law, you might face different rules of ethics that might in fact conflict. So if you have an active practice in California and New York, remember I said I'm interested in large law firms, so right, that might be, it's not an academic concern. Right? You're facing different federal judges with different rules of ethics that might conflict. Okay, so to conclude, what I hope we'll be able to discuss in just a few minutes is the issue of the appropriate role of judges in regulating lawyers, appreciating, as I hope I was able to convince you, that the basic insight, the judges, of course, ought to regulate lawyers who appear in practice before them because they have the capacity to do so so far as misconduct is being engaging in front of them, to simply assume that would amount to a significant simplification of the practice realities faced both by judges and by lawyers who appear before them. Thank you.
Thank you, Professor.
Good afternoon. I see we have a distinguished audience as well, including a justice who reviews my work, so I have to be very careful in what I say here today. The questions of judicial ethics and accountability raises a number of sub-questions, including, I guess the obvious one is who is going to be doing the regulating? This is I'll tell a couple of war stories, but I think it'll be helpful to put things in context. 2 or 3 years ago, I forget when, but State Bar President, then State Bar President Shelley Sloan appointed a task force to develop standards of civility for the legal profession. I did serve on that task force. In one meeting, we were discussing whether or not it would be appropriate to include standards of civility for judges similar to those prepared by Abota. And we didn't go too far in that regard because there was a firestorm of criticism, and I think the criticism was fair. It was we as judges are not regulated by the state bar, so therefore what the state bar drafts doesn't mean anything to us, and they have no ability to discipline us, so it's not a proper exercise. Well, actually that's not a good argument in one respect. That is because the guidelines of civility and professionalism that were enacted for lawyers have no enforcement mechanism. It's voluntary. In fact, you could voluntarily agree. I, as a judge, can't sanction anybody, and so they're strictly voluntary. Now, just because they're voluntary doesn't mean that you can't utilize them to improve civility, which I think we have done effectively in some situations. But back to the judges, there is a code of canons of judicial ethics, which are, I think, probably copies, or at least portions of it in your materials, which are pretty comprehensive and cover most aspects that you would cover in rules for attorneys. Now, there is, in my opinion, if a judge is going to expect civility from the attorneys appearing before him or her, then they have an obligation to be civil as well. And there are reports of judges who aren't always civil, and I think it's important that since being a judge is really a self-regulated profession in some regards, I think it's important that each individual judge takes it upon themselves to work in a civil manner and apply the guidelines of civility in their courtroom. And by applying, I mean insisting that attorneys follow such rules and take appropriate action when they don't. We do have a bully pulpit, and if we call somebody out in a written opinion who has acted uncivilly and unprofessionally, I think that has probably as much impact as a sanction, as a monetary sanction. So the lack of sanction authority doesn't mean there's not an appropriate enforcement mechanism. Now, we're talking about civility and professionalism. It's interesting because I think right now it's a society-wide problem. Politics is extremely uncivil. Driving on the freeway, uncivil. So it permeates our entire country, and people see people acting that way, think it's appropriate to act that way, they follow, and I think it's time for everybody to step up and try to end this cycle. I know there was a congressman who was making a nationwide tour, I think on his own hook, preaching for civility in everyday life, and he spoke, I think, at UC Davis a couple of days ago, and unfortunately there wasn't a big audience and didn't get a lot of publicity. But we have to recognize that the courtroom is a little tiny bit of society, but reflects what's going out there. Now, allow me to talk about two so-called war stories, but I think it illustrates the point I'm trying to make. I had a case where the attorney in the other side was representing himself. They were just at each other's throat the entire time. Finally, the pro per dropped his motion for discovery, to get discovery. And the reason was, he stated, is I don't want to put up with the sort of stuff I've been putting up with. Here's what opposing counsel faxed me a couple of days ago. And the fact, you wouldn't believe the facts. Talk about ad hominem attacks. You have a, I can't remember what the words were now. His face was described in some derogatory manner and went downhill from there. So what I did is I wrote a tentative ruling and published it. Published it meaning it went on our internet and it was a public ruling, which I went on for about a page and a half, in which I severely chastise the guy. So first of all, motion is dropped. The reason why it was dropped is because of facts. And I described a portion of the facts. And then I indicated that we have the rules, the guidelines of civility and professionalism adopted by the state bar. We also have local county bar association rules. This conduct violated that rule, and I will not tolerate that. I expect all attorneys to appear before me, blah, 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 blah. Well, this attorney has a reputation of being close to the line about everything he does. About 6 months later, there was another, the same case, same parties. The party representing himself filed the motion to exclude the attorney who represented the other party from the pro per deposition. And of course, it's pretty tough to do. But anyway,
that's doable.
Yeah, he cited certain things and attached. No, he just said he was being obstreperous, and he copied my ruling from 6 months prior and saying, just gotta get him out of here. So the attorney, in response, produced a portion of the transcript. And if anybody was acting uncivil, it was the pro per litigant at that time. And on the record, what the attorney, said, says, I know you're trying to draw me out, but I'm on Judge McMaster's probation, and I refuse to do it. So that had an impact, at least, and that attorney's been fined ever since, at least in front of me. So, and we do have, our local court rules adopt the state bar guidelines that are in your materials, as well as local county rules. And I've made an effort, as with some other judges who are on that task force, is we had a class back when we had money to have continuing education, in which we put together a 2-hour class on the theory is if the judges don't take an interest in enforcing that, then the whole project is not going to go very far. So I think judges need to be aware of that and take a role in it. Judges, when they take office, pretty much give up a lot of their rights to freedom of speech. For example, you can't publicly comment about any pending litigation or pending initiative, I don't think you can even sign an initiative measure because it could come before you for a ruling, and it's kind of hard to, you would have to disqualify yourself, I think, and also the rules say for judges you have to avoid acts that will lead to your disqualification, including you have to limit your stock holdings and things like that. Well, the Supreme Court just went through that same thing because they had too many people disqualifying themselves because of shares of stock they own. So judges have to make sure they don't engage in activity that could disqualify them from a particular case. Now, intra-judicial branch discussions, I think there is more of a free speech, although there's limits. Right now, I don't know how many of you are in California, but right now there's, let's say, a discussion between a group of judges who think that the administrative office of the courts is unsupervised and does what they want without any kind of review, and the administrative office of the courts and the judicial council. But I think we have a right to speak out, and I think that everybody has a right to speak on those issues. But there's also a rule that says, thou shalt not publicly criticize another judge. Well, the Chief Justice referred to me as being strident and referred to another judge as being shrill, who happened to be a woman judge. So, that's kind of getting close to the line. I'm not charging the chief with any misconduct because that would be criticizing him. But I mean, so want to make clear that. I'm just reporting the fact that's in the public record. I mean, this is in newspapers that went out. So there are standards on what you have to keep the debate on a certain level and not get personal. even though you may have more freedom to discuss things within the branch than we do publicly. The rest of the matters, I think we'll just leave for discussion by our panel.
Thank you, Judge. I thought you comported your comments very nicely to the standards that might apply to a discussion among the powers that be within the court thing over there in San Francisco. But anyway, interestingly, I belong to an organization by the name of ABOTA, the American Board of Trial Advocates, and I was speaking with His Honor from Nebraska about ABOTA, and interestingly, they have a protocol that they encourage all ABOTA members to follow in response to an unfair criticism of a judge that comes out publicly. Trial lawyers, this organization supports the perpetual existence of the civil justice system and the right to a jury trial and ethics and civility and professionalism, and they see our organization as having a responsibility to step in because the judges can't always speak on their own behalf, and lead the charge when there's unfair criticism of judges in the public square. As far as, what I'd like to do is to go back very briefly to judges in the courtroom and ask you gentlemen a couple of questions. I think the political area we've sort of hit a number of different ways today. We might be able to run through that because I want to eventually get to, and in a deep way, the media, because I think that therein are some pretty provocative issues we might talk about. But as far as judges in the courtroom, and this is for any of you, what should a lawyer do? I'm mindful of Vincent Bugliosi's book, And the Sea Will Tell, when he was in San Francisco in a federal criminal trial defending, I think it was a murder case, defending these people that killed those family out on Palmyra Island south of Hawaii. The second half of the book is all about this locomotive federal judge that, he couldn't get a word in edgewise, he could not advance his client's position, etc. He's pretty aggressive in terms of what he recommends to the practicing lawyer. But what is available to lawyers and to other judges when you have sort of a rogue judge who, not just on one bad day, because we all have bad days, but routinely engages in, berating people and just really poor conduct in the courtroom?
Well, first thing they could do is bring a complaint before the Commission on Judicial Performance. And what that commission will do is investigate the complaint and decide whether to take action or not, and if they take action, the level of punishment. The second thing the attorney can do is complain to the presiding judge of that court, or to any other judge. If a judge becomes aware of misconduct by one of his or her fellow judges, they themselves will be subject to discipline if they don't take some action and report it. So there's a strong rule that takes seriously any kind of reports of misconduct by a judge.
Have you seen that actually work in practice in Sacramento?
Well,
without naming names.
Well, there's been judges disciplined by the commission, but I don't know whether that was the result of a complaint by an attorney or
judge
or something. I don't know the genesis of that report. I have seen it. Also, there's been when the presiding judge was informed of a matter. I think there are actually two cases. One involved another judge. One involved the subordinate judicial officer, commissioner. And in both cases, the presiding judge did meet with that particular judge, indicate what complaint there was, and what that judge or commissioner had to do to correct his behavior.
Okay, quick question over there.
Yeah, just to follow up, I think that the commission will, on the basis of any kind of credible letter, send a monitor, to the courtroom. They'll order transcripts. An attorney can order transcripts. That should be a red flag to a judge immediately if it's out of the ordinary for appeal or something. And it does work pretty well, I think. shouldn't have to. There are judges that go through their entire career and never hold anybody. There's a time for it. But one thing we really want to remember, don't take it out on the client. No matter how obnoxious the attorney is, do not take it out on the client.
Good, thank you. Any experience in federal court? Because the commission is for state court jurist. Any federal court? Is there a feeling amongst any of you that practice in federal court that there is an interest in the court as a body uplifting its level of civility and professionalism and control and the product that they deliver literally to lawyers and the general public in cases that come before them? Is that nobody believes that that's the case?
I mean, for those of folks who are from LA, I mean, there is an example, of the judiciary dealing with, a judge that was perceived to be a problem in Judge Real, who is notorious, and whether he's correct or not, or whether the complaints are, there were complaints made, and there were hearings held within this, I would say, arcane kind of federal system of judicial ethics. I mean, this is where I'm an advocate for the California way, which is just kind of straight up. I mean, judges have a regulatory agency, they got a code of conduct, there's a place to complain, they got a website, they got forms, you go there, you do it, they send monitors out, they got investigators, they got prosecutors, and judges get disciplined. I mean, I'm a regulator. I love it. I don't go for these kind of mysterious, things that go on in the federal system where you go into a room and then some people don't come out. That ain't my way, I mean, regulation isn't that. Regulation is the straight up way. So I don't know where we are with, Manny Real, but he is a poster child of that, and like I say, I don't know enough to be his advocate, defender, or accuser, but that's an example where even in that arcane system, things happened.
Just
Steve,
quick.
I'll just
Yes, please.
As a matter of timing, sometimes lawyers find themselves in a peculiar situation. So, as a member of the legal profession, of course, if you're faced with an abusive judge, you have a duty to report. There are avenues that you can report to. In fact, if the judge happens to be a member of the bar, then the rules of professional conduct say that you must report, and it's professional misconduct for you as a lawyer not to report the judge. So that becomes. But I will just add the point about timing, which is a lawyer will have to balance the duty to report a misbehaving judge with duties to the client. And it might be that it will not be in the best interest of a client to try to seek action or report a judge in the middle of a litigation. So it's a dicey situation. On the one hand, you have a duty to report. On the other hand, if you are, I can conceive of facts under which it will be in the best interest of the client to actually conclude the litigation before the judge and either take the matter as part of your appeal or then deal with it. So I completely agree with Judge McMaster, but I'll just add that there's sometimes an issue of timing of when you will initiate and a complaint and when exactly you will decide to act on it.
Of course, if the judge is totally sabotaging your case, you may have to go for the long shot,
Right.
the mistrial, which would mean that you would have to be very frank probably and be very dissatisfied with the proceedings. I just wanted to point out quickly on the website, ABOTA, within their principles of civility, integrity, and professionalism, they actually have conduct expected of judges. And I know there's some interest, the bench has, I think, shown some interest in what the trial lawyers expect, especially when coupled with the protocol for responding to the criticism of judges, because ultimately it gets back to this appearance. I know we got rid of the appearance earlier today. The appearance, how we all look to the public, does in fact affect the legitimacy and the effectiveness of certainly the civil administration of justice. Let's move into the media area if we could. Judge, yes.
I'm a judge in Monterey County, and my experience with contempt is when I was a lawyer, same other judges and how they handled it, and I have role models. I practice in front of Harry Pragerson, U.S. District Court, Matt Byrne, outstanding judges, patient. I was in front of Manuel Riel, Andy Hawk, with Steve Yagman as my co-counsel.
That's a historical moment.
Every time he made an objection, he was held in contempt of court. He was repeating the objections. I made my first objection, and I was held in contempt of court. But I do want to respond, Mr. Hawley. I used to be a state bar referee also in Los Angeles. And the federal courts do have a structured system in the Ninth Circuit Court of Appeals that Congress, in essence, and the U.S. Supreme Court ordered the Ninth Circuit to set up a better system of monitoring federal judges who abuse their power. And the Los Angeles Times took it more on itself to investigate judges in Los Angeles in print, their apparent behavior, plus the U.S. Congress, of course, subpoenaed Judge Manuel to Washington on a certain case where my colleague turned him in. But again, Steve had
You betcha.
where the and he finally got him on the bankruptcy corruption, relying on bankruptcy courts. He's no longer practicing law. But the Ninth Circuit does have a protocol, very, very formal, and a very good process.
And thank you, for educating us, on that. The Yagman case actually is referenced in my materials, and there's a quote in there because Yagman has done more to advance freedom of speech for lawyers, in the Ninth Circuit than anyone else. And the clash between Yagman and Real, if you're from LA or know that history, is almost iconic. But thank you for that and for correcting me on my assault on the federal judiciary. I take your point.
Moving into the media piece, I would suggest that the media often reports the conduct of judges and lawyers in a bad light, sometimes justified, sometimes not. How does the panel feel about the overall impact of negative reporting on the health and reputation and efficiency of the judicial system?
Well,
it's a large question.
Yeah, this is not intended necessarily as a criticism of media, but I've yet to see a story on something that I was involved in as an attorney or a judge be accurately reported. Now, we should expect that. They're not lawyers. And also they don't accurately report it and put you in a bad light as a judge. Too bad. You can't do anything about it.
I mean, the media is the media, and we would wish that they had some ethics. They do have a code, yes, they do, and good journalists adhere to it. And when you're dealing with a good journalist, it's like dealing with a good lawyer. And when you're not, in one category, it's the same as the other. I mean, I think the real challenge is how do you respond, to that effectively, and when a judge is being assaulted in the media, where the play is to the story, and the story is what sells, so there's no real interest in getting to the dull, boring legal facts. I mean, it's going to sell the sexy aspect of it that is probably the most inaccurate. And judges, I would say, from a personal perspective, are better served not personally responding to those attacks.
Well, you can't if it concerns a case.
Is it permissible for a judge to engage with a wink and a nod, so to speak, groups that he or she knows are supportive of the judiciary to be activist? And
I would say that if a judge who is being assaulted in the press for having done their job has to reach out to somebody in the bar to defend them, we're failing, because there should be a rallying point. Because as I said, the administration of justice is an industry, and administering justice is our cause and our calling. And we are linked, in that process. And when an unjust assault is occurring on a bench officer, the officers of the court, who are the bar, have a responsibility to rally correctly and to respond to that on behalf of the bench, because they are barred, ethically from doing so. But my comment also is that tit for tat doesn't work. I mean, when you're being assaulted falsely, you're dealing with somebody who's at a lower echelon. Why step down? Maintain, the higher. I mean, it's kind of turn the other cheek. Be beat your head against the wall late at night, in the dark, but keep it to yourself, and let others make the dispassionate argument that needs to be made. Because once you engage, in that back and forth, you're kind of lost in terms of maintaining integrity.
Dean Parker.
Well, Judge McMaster, I'm going to do something that may not be elegant, so please feel free not to answer. But those of us who are local admire and revere you because you were, in fact, unfairly the target of a very unattractive attempted recall, and there was an effort that was mounted to try and support you. And I don't know whether you would feel comfortable commenting.
No, I don't feel uncomfortable at all. The fact is, I was just mentioning to my fellow panelists here, as strange as that may sound, the recall experience was actually in a lot of respects a positive one. In that, before the day the story hit the paper, I received 2 phone calls, one from an attorney saying we're going to get something together and do this, and one from a judge who chairs a local response to criticism committee. The California Judges Association has a response to criticism committee, and they were in action immediately. And so the support from the bar and the fellow judges from all over the country actually was quite reassuring, and I didn't lose any sleep.
It really was. It was very striking. Question?
Just real quick, judges have been sanctioned for engaging in this. We had a judge down in San Jose who responded to an editorial in the paper and invited a reporter to one session where he thought he would make some points with this reporter, I suppose. But yeah, you just got to ignore it and rise above the fray. It's something you do not want to engage in as a judge. Judges are not supposed to be swayed by public controversy or opinions. It's right in the ethics.
I'll actually add, I agree, and I'll just add there's an instructive comparison with the experience that lawyers oftentimes have to deal with. So, you graduate from law school, and oftentimes as your initiation into the bar, all the lawyer jokes start from your friends, right? And lawyers being aggressive, and lawyers being this, and lawyers being that, and lawyers being hired guns, and so on and so forth. There's, in fact, a recent book, if you're interested, collecting lawyer jokes, by a law professor, of course. Not myself. But there's an interesting feature to criticism of lawyers that has a surprising and counterintuitive upside that judges do not benefit from, which is why I think that the unfair criticism of judges is a more serious problem than the unfair criticism of lawyers in general, which is a lot of the time lawyers who are being criticized for being too aggressive, in some weird way, that's positive advertisement, right? If the joke about you is that you are a hired gun and you will do everything in your power to help your clients, the joke to some extent represents the love-hate relationship that the American public has with the legal profession. And some lawyer jokes, in fact, have, at least in some circumstances, the potential to enhance a lawyer's reputation for being an effective advocate. If you think about criticism of judges and jokes about judges, there is no upside, right? There is no conceivable measure by which a judge can benefit in a similar way from the exposure. So the unfair criticism of judges are a very troubling and phenomenon. And I can just tell you that there's something that has been happening as of late in Colorado. It might be harder to implement in California simply because you have about a dozen more law schools than we do. Colorado has a grand total of 2. But the 2 law schools in Colorado has somewhat of an agreement that every time that there is an attack on a judge, state or federal in the state of Colorado or in the 10th Circuit Court of Appeals, the law schools come together, and it's either a joint letter by the two deans, and if we can muster it, a unanimous letter by all the members of both faculties. Now I can tell you, 100 law professors, 100 opinions, right? So sometimes it's hard to do that, but at least a letter that comes from both deans and the people who teach legal ethics on both faculties that rallies within days. So we don't let it the next day or immediately to the defense of a judge. Again, it might be a powerful statement if every dean in a California law school it might be much harder to do when there's so many more law schools and a divergence of opinion. But.
One thing our 3rd district does is they go out and, in terms of improving the perception of the bench and getting the community involved, not necessarily by inviting them to vote for judges, is they go out and remotely hold their proceedings. And there's a lot of other really laudable activities, Operation Protect and Defend, and Center for Youth Citizenship, that a lot of judges, at least in our community, participate in. All of that's great, I think, certainly for the image of the bench. But what happens with the appointment process? I mean, how do you all see the vetting of, for example, a Supreme Court nominee and what goes on in the press, regardless of what party appointed them and who they are? And, do you, on the panel, perceive that damages the integrity and reputation of our system to any extent, or is it just good old, American Wild West? They deserve to be vetted down to what they're buying at the Taylor's Market for dinner tonight.
My reaction to that, and I tend to be a pragmatist, and that means that I just deal with what is, and getting appointed to the federal bench subjects you to that process, and there are some positive aspects of that, that your entire life is going to be dissected, so that if you've got something to hide, it's going to come out. The negative side of that is that none of us are angels and pristine, and some very, very good, capable people are going to say, I'm never going to serve in that capacity because I'm not going to subject myself to that. I mean, we really reached a point where it's hard duty to be a public servant in today's world, speaking here in Sacramento, with furloughs and whatever else is going on. But no matter where it is, public service is hard, and ever harder duty. And good people who might go there are going to be deterred, whether it's because of a brutal confirmation process or whatever else.
You're with the state bar, and as you've indicated, in an enforcement capacity and all that. Is it unethical for legislators who are lawyers and licensees under the regulatory scheme? Is it unethical for them to unload publicly on one or more judicial candidates with the kind of language and characterizations that if they were just in private practice of law in their office, we would consider to be inappropriate, unseemly, unethical, and perhaps actionable?
Well, in theory, the answer to that is yes. I mean, the rules of professional conduct apply to you in whatever capacity you may be acting. So you are basically, once you take the oath and are a lawyer, you remain subject to the state bar's regulation and the governing standards until you're disbarred, die, or resign. It doesn't matter what your day job is. I mean, if you're a celebrity chef and you're admitted to the practice of law, you are covered by the rules of professional conduct. You just don't have a whole lot of opportunity to violate them when you're chopping the vegetables. But in the legislature, you may have an opportunity to violate them by lying or cheating, not that that's what goes on in the legislature, or by assaulting the integrity of judicial officers. The problem is that with a candidate for judicial office, they're not a judicial officer yet unless they're seeking appointment to a higher bench. So Section 606(8) of the Business and Professions Code says that it's the duty of every attorney to maintain, respect, due courts of justice. And that's a duty. That's a statutory duty that's fully enforceable. So theoretically, now, if you made that complaint, is the state bar going to prosecute in the good old days Willie Brown because Willie Brown was doing something in the legislature on the floor that the state bar didn't like when the state bar was in Willie Brown's district and Willie Brown was in charge of the legislature and set our fees or our revenue stream and governed the state bar's budget?
Of course not.
Of course not.
Do you have any observations? I can keep moving.
Well, I think Judge McMaster said before, when we were talking about lack of civility or the deteriorating state of civility, Judge McMaster made the point that it's a larger phenomenon. It's not just lawyers and judges. We're experiencing a decline in a greater context, and the same can be said about the scrutiny to which public officials, judges, and otherwise are now subjected to. So. It's lamentable. I think that the experience of the confirmation of Justice Sotomayor was somewhat instructive of how perhaps lawyers and law professors can do more to simply help explain some facts and let the public make whatever judgment they'd like to make. But at least my personal take was when our local, the equivalent paper, the Denver Post, called to inquire, was that at least in academic circles, and it was mentioned in another panel, we all feel that we're all realists, right? So we talk about how, in some meaningful way, it's hard to maintain a professional identity that is separate and distinct from one's personal identity. Yep. So one can try very hard to hold the line, but it's sometimes hard. And aspects of your personal identity intermingle and shape some aspects of your professional identity. And I took the comments that Justice Sotomayor made in that light. That is, so I felt that it was my duty to at least share that perspective. Yeah. But I simply think that it's greatest scrutiny is a fact of life in the 21st century. And if we end up losing some competent people, that's lamentable.
I want to go ahead. Yes, Your Honor.
Mr. Hawley, citation of Business and Profession Code section 6068, which regulates, has all the rules regulating the attorneys in California apart from the state bar rules. 6068F provided that an attorney shall, quote, abstain from all offensive personality, unquote. Seems to me that covered everything.
And that believe me,
unfortunately, it's declared unconstitutional, and that's why we had the...
That was one of my favorite pieces of attorney regulation that the attorneys were not required to have, but were prohibited from having an offensive personality.
We just couldn't leave the house in the morning. Other than that, we're fine.
The Ninth Circuit actually found that, unconstitutionally vague, although conduct unbecoming an attorney was constitutionally sound. And frankly, I know an offensive personality when I see it. I don't know conduct unbecoming, but that battle's over.
It's just why we're afraid of the state bar. No, just kidding.
And well,
let me just make a couple of. I just want to make a couple of comments. First of all, we can't leave. I just want you to go with the information that I think I've asked these gentlemen ahead of time, and retired judges can go say whatever they want, I suppose. My question is does somebody that projects himself to be a bona fide retired judge with something to say, like a Judge Napolitano, it's a pretty impressive fellow, does he have to be careful when he writes books that really bring down in the uninitiated reading public, what's going on at our institutions? I mean, he has some good things to say, but I think it's a juicy question. I mean, he is a retired judge. He must have some love for, I'm sure, and support for our system. What happens when he writes a book, that's entitled Lies the Government Told You, Constitution in Exile, and a Nation of Sheep? It's just a little too cynical, I think, for a retired judge. But are they?
Yep, they sure are.
Secondly, this is a real low point, and then I have one more thing, then I'm done. Judge Judy. She's a retired judge, but I picked out the one I could actually read here, a quote from Judge Judy to a little pro se litigant arguing over, whether the washing machine was delivered. If you live to be 100, you will never be as smart as me. On your best day, you're not as smart as I am on my worst day. So there's some good judicial temperament that we can strive for.
Judge Judy, the person who got the most complaints to the Commission on Judicial Reforms is Judge Judy. I mean, a lot of people sending complaints.
Question over here from our Canadian friend.
It's actually more of two quick comments I wanted to just share with you from the Canadian context on particularly the question of sort of media criticism and also the question on the role of the judges in regulating uncivil behaviour by lawyers. I mentioned earlier that we have the sophomore program in Canada, and one panel that we spend about 3 hours on is a panel on judges who have been unfairly criticised. We have 3 judges who come in and tell us their stories, but not just what happened, also how they responded. And then we break the judges down into groups of 5 or 10, and they go away and they talk about this, other experiences that other judges have had. And judges find that to be a very important experience for them because they've actually shared their feelings with other judges, which they often can't do with anyone else. And they also get a number of tips from their colleagues about how do you cope with these sorts of criticisms. Yeah. So there are strategies in place because you can't answer in public in Canada, certainly you can't in the States. But we are creating mechanisms that are sort of trying to enhance the capabilities of judges to cope with these sorts of stresses. The second point I want to make goes back to the point about, well, what's the role of judges in the context of corralling sort of uncivil lawyers in the courtroom? And Professor Wald sort of talked about sort of the economic issues, the efficiency issues. But I've also found in Canada there's a third issue, and I think it may be true in the States as well. And this goes back to the point I was making about having an ethical identity earlier. My sense is that most judges sort of take their ethical identity from what they call the adversary system. That is, there are three components. That is, the first component is the set of substantive procedural rules. Second component is there's partisan representation. Third component is the neutral arbiter. And most judges, I think, by looking at the adversary system, say, look, there's meant to be partisan representation here. It's going far. It's maybe going too far. But I'm just meant to be a neutral arbiter. And so judges construct their identity of, frankly, passivity in the courtroom because they buy into the totality of the adversary system. The pitch that I try to make to them is that your ethical identity is larger than that created by the adversary system. The adversary system is a key component of our system, but it's not the totality of our system. Right? And there's a larger system here in which judges are actually meant to be ministers of justice. And so judges have a role to engage because the impact of allowing the ongoing incivility and abuse in the courtroom is usually harmful on those who are actually vulnerable in the first place. So if the judge has an obligation to be a minister of justice and not just a sort of an element of the adversary system, then that empowers them to be more interventionist and play a larger role. So for example, in one Canadian case, when there were concerns were raised, the judge said, well, litigation is not a tea party. Well, we know it's not a tea party, but when you see that the impact of some of the behavior of the lawyers is sexist, is racist, is homophobic, then judges have a larger obligation to step forward and say, I know I should, in the adversarial system, I should not intervene, but I've got this larger obligation that accepts the importance of the adversarial system, but actually plays up the importance of people's larger set of rights constitutionally.
Thank you very much. My final, Paul's going to come up. This is going to be my only attempt at scholarship today. We talked with some of you who are into philosophy and how all this relates to our discussion about ethics. I'd recommend a book that is just outstanding by Tom Woodruff, who is a professor of humanities at the University of Texas. It's called Reverence. And it really has to do with almost everything I think we're talking about here, which is the notion that there is something more important than just me. If I'm a trial lawyer and I've got a horribly, injured person, of course I'm going to be a zealous advocate. But that the overall process is more important than just that representation. And I think it's along the lines of that last point just raised by Professor Devlin. There's just a greater good, the health of our system, what we all do, whatever our roles are, that's important. And I'll end there, and I want to thank the panel. It was excellent. I'd like to give them a hand.
Thank you very much, Steve. I liked your reference to Braveheart, but I didn't have the opportunity to run out and get my kilt. So I'm with you once again in the same suit I was wearing this morning. I did want to actually take the opportunity, even though we are continuing tomorrow, we've got two exciting panels in the morning who take us from domestic to international. And of course, you're all invited to continue the conversation in the morning, first on codes of conduct and an experience in trying to translate American judicial codes of conduct and approaches in Kosovo, and then into a very important international dialogue with our distinguished international judges, as well as with Lee Swigert from the Brandeis Institute, talking about international judging, taking everything we're doing into a directly global context. That being said, I know that for many of you this will be the experience today, so I actually wanted to conclude the discussion by offering some thanks to some people who do need to be recognized for their contributions to making this all happen. I'll get to thank them again tomorrow as well. To our law review students, Evie Grosnick, the editor-in-chief, thank you very much indeed for your work, and Danny Kim, the 2009-2010 symposium editor. Our incoming editor-in-chief, Jessica Lee, and Katie Nystrom, the incoming symposium editor. You two have a very important task ahead in terms of actually taking what we're hearing and what has been written and translating that and disseminating it. That will be an important and living legacy of this event, as well as the discussions that we've got. And so thank you very much indeed for your contributions and the important work ahead. I have to again thank the Sierra Health Foundation, without whose extraordinary contribution this series of symposia simply would not happen. I'm supported, as we are in the Capitol Center, by two extraordinary individuals, Ashley Meyer, who every one of our speakers and panelists has had ongoing interaction with and who will rave about Ashley's work. as some people know, as my students in the class know, I do pay attention to details, and to find somebody who actually pays more attention to details is actually a real treat for me to be able to work with. And Ashley and Clemence Kuchera provide extraordinary support for this event as well as for so many others on campus, and we're in their debt. John McIntyre, Marketing and Promotions, the team that actually afforded the opportunity to get into the Sacramento Bee. Some of you heard the interview and the promotion on Insight on Capital Public Radio. Other promotional efforts to alumni and from our Alumni Development Department. That gets you all here and gets us noticed in terms of the important contributions that you're all making. And so we thank John and his team. To Dean Elizabeth Parker, thank you very much indeed for your continuing and important and ongoing support. Some of you will have seen out in the lobby the edition of Pacific Law, which I commend to you, that re-emphasizes the importance of ethics education here at McGeorge. And it's to your leadership, Dean Parker, and to all of my colleagues here at McGeorge that we share this mission in terms of talking about the future development of lawyers and the outreach to the community and to the community of lawyers and judges and other professionals both here at McGeorge and internationally. Students, Lindsay, Kier, Lily, thank you very much for your help. We're supported in the background by a terrific AV team, Ron Marcroft and Todd Roloff. Thank you very much indeed for your help. To all of you, for being with us, for sharing this event. We invite you back tomorrow. There's more food. We always make sure that our guests are fed, but more importantly, more food for thought. And we invite you to continue taking part in that discussion. For those of you unable to join us tomorrow, we really do appreciate your contributions here today. So please join me in thanking all of the speakers and panelists who participated in a terrific day today. Just one other administrative note before we go for the speakers and panelists. The shuttles will be waiting for you downstairs outside of Northwest Hall from about 4:45. Thank you very much again, everybody, for joining us.